DOT Compliance Help Inc. We're here to discuss some of the changes that the Federal Motor Carrier Safety Administration might be making in the near future. Just by way of introduction, DOT Compliance Help Inc. is in the business of assisting people to comply with the Federal Motor Carrier Safety Regulations, usually known as the DOT regs, which is an oversimplification. The DOT is a big organization, and the FMCSA is just one small part of that organization. A lot of people will tell you that the regs are hard to read, hard to understand, hard to follow, and that they're changing all the time. One of the things I always tell my customers is the rules really don't change that much, but there are changes from time to time, and it's not a bad idea to be aware of them and to be prepared for them. One way to do that is to go to the DOT website and read up on what's known as significant rulemakings, but quite often it's difficult to decipher what's posted there. It's kind of hard to understand. What we're doing right this minute is primarily just to give you an idea of who we are and how we explain things in a down-to-earth way that you can understand and do something with it. So just as an illustration, we're going to discuss 6 of those changes. But what I'll do is I'll try to give you the larger context. There's 104 changes, and they update this approximately 9 or 10 times a year. This is from the December 2014 list. There's 104 things that are changes that the DOT is considering, and these 104 changes are spread around the following 9 departments. Now, the one that we're going to focus on, of course, is the Federal Motor Carrier Safety Administration. This is the office within the DOT that regulates the operation of motor carriers. If you're a real estate office or a manufacturer or a trucking company or a pig farm, it doesn't matter. If you use in your business a truck that's over 10,000 pounds and you're involved in interstate commerce, you're regulated by the Federal Motor Carrier Safety Administration, and you're supposed to comply with the safety rules that are promulgated by that organization. And we're going to discuss about 6 of the things that might change in the near future. Here's the list. There's of the 104 things that the DOT is thinking about, there's 17 of those that are unique to the FMCSA, and we just picked 6. Actually, I think these are probably the 6 that are the most significant, and we'll just briefly discuss each of these 6. The first one we'll talk about today is the Motor Carrier Safety Fitness Determination. What's going on now, and what's been going on for 30 years or so, the FMCSA is supposed to conduct a compliance review and give everyone a satisfactory, conditional, or unsatisfactory safety rating. And they're doing the best they can with what they have, but there's only a few thousand people that do these investigations. And there's close to 800,000 motor carriers out there with unique DOT numbers. Some people have been given a satisfactory safety rating a long, long time ago, and they were doing things approximately correctly, and perhaps they're not doing things right today, and perhaps they would deserve a conditional or even unsatisfactory safety rating. There's a lot of people out there that are just not following the rules to the degree that they're making an honest attempt. But there's also people out there that have had a compliance review where they stumbled a little bit. Perhaps there was 2 or 3 serious violations, and maybe they have a conditional safety rating. That could have been 10 or 15 or even 20 years ago today. If, as a motor carrier, you're trying really hard to do everything right, you're still branded as conditional, which means you kind of don't know what you're doing, or you kind of break the rules. I mean, a conditional safety rating is kind of like having the scarlet letter branded on your cheek. It's going to affect you with potential customers. So what the DOT has proposed is tying the safety fitness determination to the monthly SMS scores that they publish. There's a lot more to it than that, but just in general, this seems to be a smart thing to do that would do away with that backlog of conditional safety ratings. Now, the agency says the intended effect is to reduce crashes, etc. I don't see how that could happen. Maybe indirectly, if you use your imagination, you could find a way that this is going to save lives, but far more importantly, or more logically, this should solve the problem of those persistent conditionals, and it's just another incremental change. SMS is a new way of keeping score, and everything should be brought into line with that. So This is probably just a real common sense thing. I don't really anticipate there being a lot of dissent about it. But by nature, it's going to have to be based on a new law. So this will probably only happen when it's part of the new DOT authorization bill, which might be brought about this year. Right now, everything is working under a continuation until September 30th. Hopefully, in a perfect world, we might have a new DOT authorization bill before September 30th, 2015, and this should be part of it. This would be a pretty low impact routine part of that authorization bill. Number 44, the Commercial Driver's License and Alcohol Clearinghouse. I'm sorry, Drug and Alcohol Clearinghouse. We've been testing people for drugs and alcohol since the early 1990s. If you fail a drug or alcohol test, you cannot drive a truck. There is no statute of limitations. It is illegal to drive a truck unless and until you go through the return to duty process. Where the system falls apart, though, is a lot of people have changed jobs, and in order for the system to work, every motor carrier has to communicate seamlessly with every other motor carrier, and every job seeker has to be perfectly truthful. And quite frankly, those things are not really what's happening. So the American Trucking Association proposed back in the early 1990s that the federal DOT should keep track of positive drug tests. So if anytime somebody fails a drug test, their name gets added to this list, and then a prospective employer has to check the list. It seems like a good common sense move, and I think that's what's going to happen. Obviously, there's a lot of people that are concerned about privacy, and probably some people are concerned that they might not be able to get a job because, you know, they prefer to have more freedom to use these substances. But eventually, all those objections will be overcome, and I believe we'll have this rule in place. We might hear something this year about it. With each one of these, there's always the status posting. The legal deadline is March 2014, but it's not unusual for those deadlines to be passed. But we should be expecting, you don't have to just wait and go read the DOT website every day to find out what's happening. With this particular rule, there are some states that have already initiated this clearinghouse process. So you should have a third-party administrator. You should check with that TPA and say, hey, what's going on in this state, and what have you heard that's new about the clearinghouse? Because that third-party administrator focuses on the drug and alcohol testing to the exclusion of the remainder of the FMCSRs, he might be more familiar with the specifics of what's going on with the clearinghouse rule than I am. Rule number 45, the electronic logging device rule. This, by far, without a doubt, is more important than all the other rules that are based on MAP 21, which is the current DOT law. What's going to happen, and just to make sure everybody understands where we stand today, there's a lot of motor carriers that are still using daily driver's logs, and there's a lot of drivers that are lying on their logs either because they think it's clever or that gives them more flexibility to decide when to stop and eat and that sort of thing. And you can speed for hours and hours and take a longer break and say, you know, I spent 4 hours driving and then I had a 30-minute break, when in reality, you know, maybe they exceeded the speed limit by 9 or 15 miles per hour, and that 30-minute break was really an hour break or something of that nature. But mostly, motor carriers and drivers feel compelled to drive more than they're allowed to and to falsify their logs. And then there's a lot of that going on. There's been a couple statements from the FMCSA that a very, very, very small percentage of drivers cheat on their logs, but there's some pretty smart guys out there that say that more than half of all drivers cheat on their logs, and more than half of carriers encourage or tolerate the practice. I'm obviously somewhere between that very small percentage and more than half is probably the truth. Personally, I think I lean more towards closer to half of them. But in order for us to have a new device that's going to be installed into the truck, that's going to solve that problem, we all have to understand how that device works. So part one here, it establishes the minimum performance and design standards. Interestingly, the DOT has said, anybody that wants to manufacture one of these things, tell us about it, and we will publish the name of the company and the name of the device in this new rule. So we won't have to be guessing, does this device fit this definition or not? Part number 2, this is going to make it mandatory. What we believe is going to happen, the rule is going to be published in September 2015, and it's going to make these devices mandatory within 2 years of the date of publication for everybody that's been filling out logs every day. If you always use the 100 air mile radius exemption and you never fill out logs, we believe that the final rule is going to say that you don't have to have the electronic logging devices. But what's probably going to happen is the manufacturers, the truck manufacturers, are going to have to start putting these in new commercial motor vehicles. So in a few more years, it won't matter if you're local or long distance. All the trucks are going to have these electronic logging devices. Supporting documents, you're still going to have supporting documents. And there was this concern, which I think is kind of specious myself, about harassment resulting from use of electronic logging devices. But yet, it's a legal concern. It has to be addressed. So the agency says we're going to put in place some specific measures concerning that. So we really expect to know the absolute, here's what's going to happen by September of this year. Number 47, inspection, repair, and maintenance, daily vehicle inspection reports. This is pretty cut and dried. In fact, it really shouldn't even be on the list of proposed rulemakings because it's already in place. In December, they made this a new rule, and anybody that's in the business should be aware of it. If there's nothing wrong with the truck today, you don't have to turn in a DVIR today. There's a lot of carriers out there that have already said, we're going to continue to turn these in every day. And there's some carriers out there that are going to say, you mean we were supposed to be doing that every day? Updates to the unified registration system. This is probably a significant issue from some respects, but it's really not that big a deal. If you operate a commercial vehicle over 10,000 pounds in interstate commerce today, you have to have a DOT registration number. If you also transport something that belongs to someone else for a fee, you also have to have a motor carrier authority. Two separate things, MCS 150 for the DOT registration number, OP1 for DOT authority. But by definition, we don't regulate interstate commerce in this country. So that motor carrier designation doesn't mean anything compared to what it did 20 or 25 years ago. So it looks to me like they're just doing away with that motor carrier authority, which was just a formality anyway. What they've said here is they're going to do away with the MCS 150 and replace it with the MCSA 1. You don't have to go find it and read about it and figure out how to fill it out, because when you go to the DOT website, there's a link from your SMS scores. There's a link that says update your motor carrier registration information. You just click on that link. It takes you to the MCS 150 today. According to the publication, by October 2015, that link will just automatically take you to this new form. It's going to change the fee structure, which I'm kind of surprised that hasn't happened a long time ago. Financial responsibility. Every motor carrier and every broker has to have insurance. The insurance amounts were set more than 30 years ago. The cost of accidents is probably 10 times what it was then. Obviously, these insurance limits need to be adjusted, and Congress has said this should be adjusted about every 4 years, I think. So we expect to see a final publication of this within a couple of months. Ladies and gentlemen, thanks for your attention. That's just a real short sample presentation. We just wanted to give you an opportunity to see this is how DOT compliance communicates with our customers, and we'd like you to be one. Thanks.